May it please the Court, I'm Joshua Gordon. I represent the neighbors to the developer, the Scanlon, Lilienthal, and Baroni. This case isn't about ocean views, density formulas, or even condominiums. It's about competing visions of community economic success in Hampton. The Scanlons and their neighbors believe that the key to Hampton's success, as it's been for 100 years, is as a summertime resort community. Outsiders come for a few days, they bring their families, they spend their money, and they go home. My clients make their annual income in a short, busy time frame. This vision, this model is chaotic, a little seedy, somewhat transient. Many of the rooming houses are owner-occupied. It's human scale, not too ambitious. The vision, however, is quaint. It looks like an old New England fishing village. The success is evident on any day in the summer or any Saturday night, regardless of the weather. In the summertime, Hampton Beach is packed. The other competing vision of community success in Hampton, espoused mostly by the town fathers, believes that the old resort community model no longer works, and the way to future success is to make Hampton Beach a year-round community. They want more stability, less dependence on the vagaries of the tourist industry. They want more permanent residents, perhaps older, following current demographic trends. They want year-round housing on the beach block. They want more stable businesses, a grocery store, dry cleaners, rather than another trinket shop or ice cream parlor. They want to change Hampton Beach to make it more upscale. The Superior Court summarized this vision well when it used the word elegant, referring to the building. The reason, the reason for this vision is evident on any day in the wintertime or any day, any season except summer. Hampton Beach is often very quiet. I don't know which vision is right or wrong, but it's not my business to decide, and it's not this court's business to decide. Because the first model, the quaint resort community, is enshrined in Hampton's zoning ordinance. Its preamble calls Hampton a resort community. The ordinance says if you want to build a place for visitors, a hotel for instance, it can be virtually to the lot lines. But if you want to build housing for year-round residents, you need larger lot size, open space around the building, bigger living units, less density, and more recreation area. The zoning districts label business seasonal encapsulate what the voters of Hampton Beach want it to be. To get a variance from this, vertical, and I love that name, has to prove unnecessary hardship. And as all variance cases, we're talking about what unnecessary means. Hardship that is unnecessary is hardship that is peculiar to the property, not suffered by others in the zone, and compliance with which is unnecessary to carry out the spirit of the ordinance. Vertical has to show uniqueness, that the ordinance hits this property in some peculiar way not intended by the ordinance. But these are standard lots. There's no evidence of uniqueness here. None was offered. Vertical has to show compliance isn't feasible. As to height, it can just lop off the towers. Vertical conceded those towers are merely aesthetic, and it would be only 4 or 5 feet above the 50-foot limit if they took off the towers. But as to bulk, given the setbacks for multifamily uses in Hampton Beach, it is not reasonable to build a big condo. You can build a big hotel. Vertical has made this general allegation regarding too short a season to make money, but there's no facts on the record on this issue, just an uncited allegation. Vertical has to show no diminution in value to its neighbors. But if you build a big, beautiful condo next to ramshackle guest houses, you devalue the property. It goes from a parking lot full of Chevys to your Chevy next to a shiny new Mercedes. And Vertical presented an appraiser's letter, but it contains only opinion and no facts. Vertical has to show that variance is in the public interest. The interest it alleges is to, quote, promote year-round occupancy, stimulating the business community to meet needs incidental to such occupancy. This is an excellent expression of the competing vision. Contrasted with Hampton's existing ordinance, its stock in trade, the quaintness of an old New England fishing village resort community, which the ordinance makes clear it intends to preserve.
Trial court found that there was no other reasonably feasible way to achieve their proposed use, and there's no financially viable alternative to make reasonable use of the property. If that finding is supported by the record, do you lose?
No. First, it's not supported by the record. There's no evidence of it. But it's only one of 5.
Well, I meant on the unnecessary hardship prong. Do you lose on that prong?
No, you still have to prove, it still has to prove that there's some uniqueness in the property. And no evidence of that was offered either. So the answer is no, I believe.
Thank you.
Thank you.